Hello, this is Angela Brumpton. Good morning, good afternoon to you. I've decided today to look at settlement agreements, and the reason I've picked settlement agreements is because if you're in business, you'll use them, you'll know all about them, you'll know what they are, and actually it's very easy to forget that they are very legally technical documents. If you don't have a good working knowledge of how they work and also how to introduce them, they can actually go quite badly wrong. And you don't want them to go wrong, you want them to work and you want to exit your employees quickly and cleanly so you all have certainty. So today we're going to have a quick look at how they work, consider some common clauses and some common problems, things to be aware of if you're responsible for drafting and producing settlement agreements on behalf of your organisation, and then we'll cover just a couple of practical tips. It'll probably take less than an hour, so it'll be relatively short and sweet. If you do have any questions, if you could send them in and I'll look to answer as many as I can at the end, or if you prefer, you can drop me a line or give me a call after the webinar's over, and I can answer any queries that you've got. Okay, so what is a settlement agreement? If you're relatively new to HR or employment law, you might come across people calling or referring to them as compromise agreements. And that was their name before July 2013. So if you hear references to compromise agreements or people using that term, they are settlement agreements, they're one and the same. And it was felt that settlement was a better term than compromise because it better reflected what was actually happening and it was a more widely understood term. I also understand that people didn't like the word compromise agreement because it sounded too conciliatory, and I experienced this myself from my clients who use the word compromise. It automatically sounds as if you're asking individual clients, so an employee, to compromise their claims, and it wasn't a very popular term. So we now use the word settlement agreements. If you do have old version settlement agreements, and I hope you don't because this wording was changed in 2013, but be sure that your old, your versions of your settlement agreements do say settlement agreement and they don't say compromise agreements. So you just need to update your precedents. A new ACAS code of practice was also issued in 2013 on settlement agreements, which we still use, quite easy to follow, so I'd recommend that you have a little look at that. Failure to follow the code won't of itself make any person or organisation liable in tribunal proceedings, but an employment tribunal will take any failure to follow it into account where it's relevant. So do familiarise yourself with it. As I say, it's not difficult to understand. They're more general sort of guidance, but do take the time to have a read if you deal a lot with settlement agreements. And the final point there is that the entire point of a settlement agreement is that they settle all and any claims that an employee may have an employment tribunal in return for something valuable, something they usually wouldn't ordinarily get by way of the contract, so something additional. Basic laws of contract there, you offer something and it's accepted and it's something valuable that the employee wouldn't ordinarily be able to access. In terms of settling all claims, there are a couple of exceptions. In fact, there are three which I'll refer to now. These usually are spelt out in the settlement agreement for clarity. If they're not spelt out in the settlement agreement, they still apply. It's just people prefer to have that sort of express clarity there. The first one is to enforce the terms of the settlement agreement itself. Obviously, it wouldn't make any sense if the employee couldn't sue an employer for failure to comply with the terms of the settlement agreement. So that's usually an exception. Any latent personal injury claims of which the employee is not aware. So what that means is any personal injury claims which you are not aware of that you may have against your employer and which you couldn't reasonably be aware of. So if you know that you've suffered stress at work and you later decide that this is something actionable via personal injury, even though you might not have been contemplating a claim during your employment, you could reasonably have known or you could have reasonably been aware that you may have a claim. And therefore that would be covered, you wouldn't be able to bring that claim. The only example of a latent personal injury claim that an employee is not aware of at the time they sign the agreement and couldn't be aware of, the only practical example I can ever come up with is if you find out, God forbid, in 10, 15 years' time that you were breathing in asbestos while you were there and you've now got a lung condition, that wouldn't be covered because it's not something you knew about and you couldn't have been aware of it at the time. The third exception is accrued pension rights. And again, for the same reason, you may not be aware you've got any pension claims until some years from now, they would not be covered. Otherwise, everything else is. And when I advise employees, who have been offered a settlement agreement, generally my advice is, if you think you may have any claims at all, whatever they are, you need to speak now, because once you've signed this agreement, you should just assume that that you're not allowed to bring any of them at all. Most well-drafted settlement agreements contain indemnities in them in favour of the employer, which state that if the employee seeks to bring a claim against them, even if it's unsuccessful or even if they don't get very far, the employer can seek their costs for doing so. So from an employee's perspective, once it's signed, generally speaking, you've signed away all your rights, and both parties can go forward knowing that there's not going to be any further action. Okay, pre-termination negotiations. We used to have the without prejudice rule that we relied on when we were broaching settlement agreements with members of staff. So how are pre-termination negotiations or discussions different from what we had with the without prejudice rule? When we had without prejudice discussions, that meant that the content of the conversation wasn't disclosable or isn't disclosable in tribunal proceedings. The problem was you needed a dispute in place as an employer before you brought them up, you brought up settlement. You couldn't just invite an employee to a meeting one day and raise an issue with them and say, here's a settlement agreement. There had to be a dispute in place. Now, in practice, this led to an awful lot of expensive satellite litigation around what was a dispute. And the case that I always refer to, because it's a very good illustration of how these things could go wrong, was the BNP Paribas and Mezzatero case. Mrs. Mezzatero brought a grievance against her employer about her treatment while she was on maternity leave. Before the meeting had actually taken place, so she came in, my understanding is she actually came into the building for a meeting about her grievance, but was brought into a separate meeting and offered a settlement agreement on a without prejudice basis. She refused the settlement agreement and then resigned in response to that meeting, saying that even having that discussion with her was a breach of mutual trust and confidence, because it was a clear indication that her employer had no intention of properly investigating her grievance and finding in her favour. She brought a claim for, amongst other things, constructive unfair dismissal, and relied upon the content of that conversation, which her employer said, unsurprisingly, was privileged. It was a without prejudice conversation. You can't rely on it as a breach of contract. Unfortunately for the employer, the tribunal disagreed, and they said that there was no dispute in place at the time, because all she had done was raise an issue via the grievance process. It hadn't been investigated and there hadn't been an answer to that issue, and therefore at the material time there was no dispute. So with a protected conversation, this wouldn't have happened. It would have been a lot easier for them to simply bring it to one side and say, we'd like to make you an offer and we're going to have a pre-termination discussion with you. All you have to do is to mention that you want to have a protected conversation and make it clear that that's what's happening. Makes it an awful lot easier for all involved, really. That's not to say, you know, from an employee relations perspective, in an ideal world, we wouldn't be inviting individuals in to meetings that they're not expecting and they don't know there's a problem and saying, we want you out. Personally, I think that's not ideal. However, there are circumstances in which that's absolutely necessary or desirable, and therefore these changes, this pre-termination discussion legislation brought in, has made things an awful lot easier. That said, don't make the mistake of treating it as an opportunity to say exactly what you like to an employee, because there are some exceptions. The without prejudice rule for pre-termination negotiations doesn't apply to claims for automatically unfair dismissal or unlawful discrimination. So if the reason for the meeting is discriminatory, or the conduct or content of the pre-termination discussion is discriminatory, then it won't benefit from being undisclosable. That's really because the tribunal won't allow it to be used as a cloak for unlawful behaviour. So it's not a forum for you to say whatever you like to the employee. There may be circumstances in which the employee can disclose that to a tribunal. Equally, it doesn't apply if the tribunal believes there was other types of improper conduct and that it is just to admit the evidence. So a really good illustrative case, it's not actually a reported case, but it was one that was taken by my colleague. And this was an individual who had being called in by his manager for a pre-termination discussion. It was expressed to be a pre-termination discussion. However, the manager had, for reasons unbeknownst to us, decided the best way to do it was to invite him into his car and blow smoke into his face in an intimidating fashion. So what had actually happened is he'd brought the employee into his car and said, we want to make you an offer to leave, but you are going. It was all done in a very unsavoury fashion. And the employee relied upon that conduct, resigned, brought a claim for unfair dismissal, and a pre-hearing discussion took place to determine whether or not the employee could actually rely on the content of that conversation. And the judge in that case said, yes, it is disclosable because we think that was improper conduct, or certainly there's an argument to say that the manager behaved improperly and doesn't benefit from that being non-disclosable. So therefore, my advice to all employers, anybody embarking upon pre-termination discussions with an employee, is you should always conduct yourself in such a way that you won't mind if a judge in a courtroom hears what you have to say. Really, employment tribunal judges are very disinterested in general in people having protected conversations. They are very commercially common. They happen all the time. So if the tribunal finds out that a business has tried to settle a matter and had a pre-termination discussion, it will not influence them one way or the other. They are not interested. There are circumstances such as allegations of discrimination, etc., whereby the content of your discussion is going to be disclosed, and therefore you want to be in a position whereby you say, I don't think it should be disclosed, but I don't mind if you hear what I have to say because I didn't do anything wrong. So always conduct yourself in such a way that you're happy for everybody else to hear potentially what it is you have to say. And there are some tricks in that, really. It's all about making the offer in such a way that you're not intimidating or threatening the employee. A classic example is you have performance management on the cards. You say to the employee, we're going to embark upon a process. We'd like to make you an offer to leave now in a dignified manner with a good reference, perhaps. However, if you refuse the offer, you will face a fair process. We will guarantee you that we will go through a process that is fair and objective. If that were to get out into the open, no one's going to be particularly interested in that conversation. You haven't really done anything wrong. There are some circumstances, limited circumstances, when the employer may decide or seek the right to disclose the conversation with regard to costs or expenses if you ever got yourself into that position. Very unusual, mainly because most employers don't recover costs in an employment tribunal, but it is possible for you to seek to do that if that were to become relevant. Okay, so why settle? And this is a question I'm asked a lot. I have employers who have perhaps taken some time and effort to embark upon fair processes, and they don't want to offer settlement agreements because maybe they're a bit more expensive than simply letting an employee go. You have to contribute to legal costs, which we'll come on to later. And when they say, well, why should we settle? I mean, I've been in practice for many, many years now, and the more experienced I get, the more convinced I am that really an employment tribunal is your sort of last resort. It should be everybody's last resort. If you can get things settled amicably and settled well without resorting to that litigation, that is usually preferable. And only in the most difficult of circumstances should you end up thrashing things out in a tribunal. A settlement gives you both certainty and closure. Probably more important for the employer, who knows, particularly in a classic sort of redundancy situation, for example, if you're offering any form of enhanced redundancy, why not use a settlement agreement to get something in return for that enhancement, which is a promise that this really will be the end of it. You can then manage your cost going forward and know that an employee is not going to come out of the woodwork in a couple of months' time and start costing you an awful lot more in tribunal fees. So certainty and closure, particularly if you've got other things to get on with, it is a big one. An agreed outcome is more likely to be acceptable to both parties rather than just to the winner in court. And in my experience as an employer, if you win in an employment tribunal, you are highly unlikely to get any costs at all. If you do get costs, they are highly unlikely, in fact, probably never, they never cover all of the cost involved. They certainly don't cover the cost of your time and preparation. And therefore, rather than feel jubilant, you probably feel, the overriding emotion is relief and justification, and you still have to pay all your legal fees. It avoids the cost of continuing with litigation. Management time, this is another really important one, because no matter how gung-ho you feel about employment tribunal proceedings, everybody has to be committed to that time. So that's not just the time of attending an employment tribunal hearing and giving your evidence, which could be over multi-days, but it's also about the preparation time before that, preparing witness statements, answering questions, finding documents, checking bundles. All of those things require a time commitment, and that is a knock-on expense for a business. By reaching a settlement, you can avoid the public arena if you need to. These days, I have to say, press tend to be reasonably disinterested in your bog standard unfair dismissal claim or your wages claim. You won't find many reporters in a tribunal looking at that, but certainly anything that is more salacious, anything more juicy, they may be interested in it. And of course, either party can tip off the press and ask them to attend, which is, which may be a consideration for you if you want to avoid that sort of publicity. There might be other commercial reasons to settle. For example, if you bid for public contracts, you may be asked to disclose any claims against you. And the more you have, the more problematic that is. So you may want to avoid claims no matter what their merit. You may be about to buy or sell a business, and you could do without having to deal with these issues, or also having to disclose them to a potential buyer, for example. So there may be many different reasons why you would want to settle. And another thing to consider is there is a wider range of remedies available when you're settling a dispute than is available through litigation. We're going to come on to talk a little bit more about this in the presentation, but generally speaking, you can really settle how you want in a settlement agreement. Tribunals' remedies are fairly limited. They're limited to financial awards and also re-engagement and reinstatement. They can't order an employer to give a reference. They can't order them to waive covenants. There's all sorts of different things that you can put into a settlement agreement that might be valuable to the employee and not so costly to you. That's going to encourage a settlement to take place. I've done a settlement agreement before, I've certainly seen one before, where there's been a promise made to give work experience to somebody's son. There's all kinds of things we can come up with. Just on the point of the tribunal remedies, the fact that a tribunal can order re-engagement and reinstatement often goes very much under the radar for some reason. Now, the fact is, in practice, many employees will be seeking re-engagement or reinstatement as a remedy. They don't want to come back and work for you if things have ended badly. But some employees do. Some employees want to come back to the role they were in. It may be unusual, and it's maybe quite unusual for a tribunal to award it, but they can award it. They do award it, and I have had experience of that happening, and I've seen sort of how devastating it is for an employer to have to take back an employee they really don't want back in the business for various reasons. So another good reason to settle, maybe. Okay, requirements for a valid settlement agreement. And the reason I'm bringing this up is because when we have draft settlement agreements, and you've probably got drafts available in your business, there's an awful lot of what we call boilerplate clauses in there, which are in every agreement and they're standard. And because they're standard and they're always there, we tend to ignore them. And actually, they're all very important. They all must be present, or most of them must be present usually, to make the settlement agreement binding. And they've got to be properly drafted. So I'm going to bring some of these up because some of you listening, many of you listening will probably get involved in drafting settlement agreements, and the temptation often is to cut and paste a settlement agreement that you've been given earlier, perhaps by your legal representative or one you've used before. And whilst I can see why people do that, especially if you've had a very recent one, I think it's really important that you're aware of how the clauses operate and what you need in there to make sure that you're not doing something that's going to really damage your prospects. Because the first thing is the agreement must be in writing. Hopefully that's a given. It can't really just be written on a piece of paper. There have to be certain things that are present there. The agreement must relate to the particular complaint or the proceedings. So it has to state what complaint it is intended to cover. So most settlement agreements will have a huge list, probably in a schedule at the end, or buried in the middle of the settlement agreement, of all of the claims that could possibly be brought on earth that are covered. However, in the recitals at the beginning, we usually set out what particular claims are being contemplated for this particular case. Now, these are really important because they are the particular complaints that you're settling. And if you don't state what they are, it can actually jeopardise your the whole enforceability of your agreement as against any particular individual. So these are really important The agreement must state that the applicable statutory conditions have been satisfied. So again, that's buried away in the settlement agreement. You'll see a paragraph there talking about statutory conditions. That must be in there. Don't be tempted to leave that out. If that is not written into an agreement, the entire thing is void. So I've seen settlement agreements achieved at tribunal steps, for example, that are very, very minimal, but they don't include this statement, and therefore it makes them not binding, in that the individual could still revive a claim in an employment tribunal. So it's very important that that is there. And the employee must have received advice from an independent advisor. This isn't optional. They must take legal advice. I have had some clients, and many people think it is an option, that they can waive. They can't. It has to be signed off by an independent advisor. They can't go to your in-house lawyer or your lawyer for advice. You can certainly direct them to somebody if you want to make some helpful suggestions about solicitors who've done settlement agreements on the other side before. But you can't force them to go to a particular solicitor. They have to be able to choose. So as an employer, if you do a lot of settlement agreements, you might have reached an agreement with another solicitor for a fixed fee. Certainly I've entered into those arrangements before, whereby an employer has a lot of settlement agreements and therefore says, we'll direct them your way if you will agree to sort of slightly lower than average contribution towards your legal fees, or perhaps even a good contribution. That's fine to do that, and you can certainly direct your employees there, but you can't make them use that service. They have to elect somebody of their choosing. The independent advisor must advise the employee on the terms and effect of the proposed agreement. Really, what this means is that they must advise them on what the settlement agreement means for them. So in terms of the waiver of all their claims, but also in relation to any of the specific clauses there. They're not necessarily there. It's not required that they advise on the strength of the deal, so whether or not they've got a particularly good deal or not. Naturally, that's a question employees often ask. Some come to me for advice and say, I'm happy with the settlement, I just need you to sign it off for me, in which case I stick to the advice. Sometimes they will come and say, I feel I've been unfairly treated before I sign this. Are there any other claims I can investigate? Those are natural questions, but really the advice that is necessary to get the agreement signed off is just on its terms and effect. And the employer has to be expressly identified in the agreement. They also have to sign their advisor's schedule at the end, which will state words along the lines of they have a current contract of insurance or indemnity insurance covering the risk of claims. And again, all of these are absolutely critical in the validity of your settlement agreement. I suppose the good news is if wrong advice is given to an employee, then the employee may sue that legal advisor. They won't come back to you for offering them a defunct settlement agreement. They will come back to their legal advisor and they can have a claim there. So if the advisor gets it wrong, the blame rests there. Generally, my experience when settlement agreements go wrong, which they don't very often, but it's usually in relation to tax. Sometimes taxation in settlement agreements can get very complicated, and if it isn't properly expressed or it's not properly explained to the employee, that can lead to issues. And also jurisdiction, we're going to have a look at that later on, but jurisdiction is something that's often overlooked, again because it's a very, very standard clause in a settlement agreement, but that can cause problems as well. Okay. So some common clauses then. A negotiation usually focuses around the same things time and time again. Termination date. Amazed how often this becomes a real problem. The bottom line is you can agree any date as between the parties. So the natural termination date of employment is when the agreement is signed. That's usually a natural end date. When it's completed between the parties. And that's when the employee is in employment and they're agreed to terminate the employment. That's quite standard. However, it can be any other date, past or present. So it can be a date in the past, as long as it's been agreed, or it can be a date in the future, as long as it's agreed. So there's no real bar on it. An employer can't insist that an employee's termination date is recorded as, say, 2 weeks earlier, even though they haven't been dismissed yet. You could agree that date between the parties. If the employee agrees, that's absolutely fine. But if the employee doesn't agree, the employer can't arbitrarily decide you actually terminated 2 weeks ago, even though you're still employed now. But the key is you can agree what you want whenever is convenient. If you are agreeing a future date for termination, then I strongly recommend that you get a reaffirmation letter in place. Your solicitor, if you're using a solicitor, should know about this anyway and should advise you to do that. What it is when the employee signs the agreement, they may sign it on the 1st of July, they're not leaving until the 2nd of November, for example. Anything that happens between them signing the agreement and leaving could be the focus of a claim. So if they decide they are sexually harassed in that period, they can bring a claim. If they decide something else has happened, they can resign and bring a claim. So I would recommend you get what's called a reaffirmation letter, which makes it conditional upon the employee having signed the settlement agreement at the end of the employment to go and back to a solicitor, get a reaffirmation letter signed to say they're confirming that there are no further claims, nothing's happened in the interim period, and they're happy to reaffirm the settlement agreement. So again, if you're using a lawyer, they should come up with that for you. But if you are considering, or you do use future dates in settlement agreements for termination, I would really recommend that to protect your position. Payment of salary and accrued holiday up to and including the termination date. This is subject to tax in the usual way. There is no way around this. It must be paid and it must be taxed in the usual way. Payment in lieu of notice. So historically, we could have some fun with this. If your employee didn't have a payment in lieu of notice clause in their contract, an employer could wrap up their notice and pay them in lieu, but without taxing the payment. This is because it could be paid as a severance agreement, as part of a settlement. Useful in a lot of ways to employers because it meant the employee was getting more than they would otherwise be entitled to, so they were happy and it was costing the employee nothing more than it would have cost them. HMRC have decided to close this loophole. They'll always find ways to get hold of their cut of the tax, and what they've said is it doesn't matter. Now, from April 2018, it doesn't matter what you've got on your contract. If you are paying a sum of money with reference to notice, it must be taxed. There's lots of sort of, if you read about this, they make it sound all very complicated, but it all boils down to the same thing. You need to separate an amount in respect of post-employment notice pay, as they call it, PEMP. That means your settlement agreements now need to be extremely clear about notice. If an individual has worked their notice, that needs to be clearly expressed. If you're paying in lieu of an element of notice, that sum needs to be separately carved out, and you need to make it clear that you're taxing that sum. If you don't do that and HMRC come nosing about in your settlement agreements, they're going to open them all up, and they're also going to be very suspicious that you've actually taken steps to deprive them of a taxation payment, and you don't really want them thinking that. So your settlement agreements, if you're using old ones, they need to be amended to make sure that notice is clearly dealt with. And then we get on to compensation for loss of employment, so ex gratia payments and tax. Once you've paid your tax on your salary and your notice, any compensation payment up to the first £30,000 can be made tax-free. So that means any payment that is truly ex gratia, it's not something payable by reference to the contract. It's a discretionary amount, and up to the first £30,000, that can be tax-free. Relatively straightforward. Most settlement agreements, in fact all of them, should include a tax indemnity in favour of the employer, saying that if for any reason that position changes or HMRC decide that tax is paid for some reason or payable, then the employee is responsible for that tax. And I advise employees who get worried about this all the time and say, look, if you needed to pay tax on it, that's your responsibility. But the fact is, it's not going to happen. If we've drafted the settlement agreement properly and clearly, it's not going to get interfered with. It's not on the slide, but it should really be there, is waiver of claims. We've talked about what claims are waived and what claims can't be waived. And one of the things I just want to flag is future claims. So all settlement agreements contain a sentence in it which will say something like, they're settling these claims and all and any other claims arising out of or in connection with their employment, whether they know about them now or whether they arise in the future. There's been lots and lots of debate and case law on this, but it seems clear to me from case law now, and it's generally considered right, that future claims can't be waived. If an employee is not aware of a claim and it only comes to light in the future, then those claims aren't going to be covered. So the most obvious example is post-termination claims that may arise, such as post-termination victimisation, where something happens post-employment, but as a continuation of any discrimination or victimisation. It's still prudent to include future claim waivers in your settlement agreement, so I don't advise getting rid of them, but they are unlikely to be effective on their own. So a good settlement agreement will include a warranty that the specified claims, so they're the claims that you specify in your recitals at the very beginning, the ones I talked about before, your specific claims are the only claims that you have, and that the employer is entering into that agreement in reliance on that warranty, and then include an indemnity in it. Quite legalistic stuff, and again, your solicitors should have this covered if you have solicitors draft and advise on your settlement agreements. But if you're doing your own, again, it's something to be aware of. Future claims, barring future claims of itself is unlikely to be ineffective. And if you're worried about that, you need to make sure that you get specific wording in there to deal with that. So if you have a concern about an employee's bringing claims in the future, even post-employment, mention it or bring it up and see if you can get the proper wording or ensure that it's in there. Okay, other common clauses, legal advice and contribution to fees. There's no requirement for an employer to make any contribution at all towards an employee's legal fees. However, it's common to contribute in order to grease the wheels. Fact is, employees aren't going to go and get this advice, or are going to be more reluctant to get this advice at their own expense, particularly before they've signed an agreement and have got any access to actual money coming their way. The standard amount for a basic settlement agreement used to be £200 to £250 plus VAT. I think that's a very antiquated amount now. It doesn't usually cover an hour of advice from a good solicitor. So I recommend £350 to £500 plus VAT as a contribution to a legal fee, if it's fairly basic. What you don't want to do is get into a position whereby you're paying the employee to negotiate with you. You will often have the other side come back and ask for an uplift in compensation. And if the renegotiation or the issues that have arisen are partly your fault, or you've left something out, or the employees being very reasonable in raising them, you might think, okay, that's fair enough. It's sort of cost them money to renegotiate this, or look at things perhaps we should have put into the agreement to begin with. It's not unreasonable for them to ask for an uplift, and we'll agree a bigger fee. That's fine. That happens all the time. However, some employees want to come back and renegotiate and argue for more and claim that you've treated them unfairly, etc. And then they want you to up the fees in order to cover them doing that. So what I would say in that circumstance is, unless there's a real commercial reason for you to get this done quickly, a good response is simply to say one of two things. Either no, because we're not paying you to negotiate better, it's costing us money for you to negotiate a better deal with us, so we're not going to do that. Or you can say, that's fine, we'll up the payment of fees to your legal advisor, but we're going to deduct it from your overall settlement package. That makes it a little bit more tax effective for you, but the overall package remains the same. How would you like me to do it? For more complicated settlement agreements involving more senior people, you are probably going to have to pay more. Where there are complex post-termination covenants to negotiate, for example, or where there are shares being divested and complicated arrangements with regard to severance, you are looking at a couple of £1,000s. In fact, usually between £3,000 and £5,000 to pay for those fees. I have seen them go a lot higher, where there's been very complicated share arrangements and disputes between the parties, and where corporate solicitors have had to get involved. So costs can sort of scramble up quite quickly, but be prepared to pay more for your more senior employees. However, your box standard settlement agreements containing fairly sort of standard clauses, you're looking at about £350 plus VAT, and I think that is a reasonable contribution. Confidentiality, always include it, and I always advise individual employees to take confidentiality very seriously, as it's a breach of confidentiality that usually sends settlement agreements going completely pear-shaped and creating problems. Some clients say to me, and I'm sympathetic to this view, that they have very limited value because in reality employees tell their friends, etc. However, it's still worth putting in there, and you never know when you may need to rely on it. So I have had one incident whereby a client did begin proceedings against an individual who breached confidentiality. They didn't complete them for various reasons, but what had happened was I was negotiating on behalf of my client to settle a very thorny case, and we made an offer that was a good offer to the other side, and the solicitor came back and said, my client's not accepting that offer, even though I think it's pretty good, because she knows that Mrs. X was paid more for her settlement. And I related that back to the client, and the only reason she could have known that is if Mrs. X had actually told her what the settlement was, clear breach by Mrs. X. And they said, right, we now have a discernible loss as a result of that breach of confidence, and we're going to take action. So legal proceedings were instigated with regard to that, although ultimately not concluded because we managed to get a settlement with the other lady, and they lost all their appetite for the fight. But I'm sure it gave that lady a horrible shock. And it did create issues. So I always advise clients to take confidentiality clauses very seriously, and they should be included. It's probably better mentioning confidentiality clauses being in the news recently, and I'm not going to go into it in great detail here. But in respect of confidentiality and sexual harassment claims, where people have signed settlement agreements in relation to sexual harassment claims, and then they've come under real scrutiny in the sort of Me Too era. That's an ongoing issue at the moment. There hasn't been any legislation come forward. Nothing's in writing. Nothing's dead certain. It's still being debated as how we deal with those going forward. Some guidance that has come out, so sort of professional guidance, opinion on how this might be dealt with in the interim, while we're still in a bit of a sort of grey area, includes if you do have a sensitive case involving harassment and you want to include a confidentiality clause in a settlement, which you of course will, that you draft an annexed statement. So you draft an annexed statement to the settlement agreement, which states why the confidentiality is necessary, states why both parties want it, so setting out the position of both parties in respect of confidentiality, and also what the effect of that confidentiality clause is in very clear terms. Will this work if somebody decides to go to the press at a later stage? I'm not sure, but it can't hurt. And one of the features of the most recent confidentiality sort of debate that went on was the fact that some of the individuals involved actually did want their confidentiality to be maintained. So still important, but still in flux in relation to certain claims. Non-derogatory statements, so again, very standard clause, which you probably put in without thinking. The individual employee will not make any derogatory statements about their employer. Increasingly now, these clauses are going in both directions, and we'll commonly see, and the company agrees to use its best endeavours or reasonable endeavours to ensure that no derogatory statements are made about the employee. Absolutely fine, very standard. One thing I would raise, and it has come up before now, is what does best endeavours or reasonable endeavours mean on behalf of the employer? Because that's how it's drafted into the agreement. In the event of an issue where the employee claims that the company has been making derogatory statements about the employee, the natural question would be, please demonstrate the best or reasonable endeavours that you took to ensure that no derogatory statements were made. Obviously, the company can't police what every single person says, but they may be called upon to show the reasonable endeavours that they took. Now, most employers, I think, if I ask them that question, show me what you did, and they would say, well, nothing, because it's kind of a boilerplate clause, and we throw it in and we sort of don't think about it too much. So the best advice would be always have an answer to that question. So it may be simply that you send an email to your managers involved, or maybe your sort of top tier managers, and say, this person's left the building, we've signed a settlement agreement, please use discretion, do not make any derogatory statements, and that would be enough. Of course, the employee may not want all of the staff of the business knowing they've left, and they've left under a settlement agreement, and that may of itself be confidential. So this can be a bit of a tricky area, but just be aware that if you're saying that you're using best endeavours or reasonable endeavours, somebody may at some point ask you to tell them what those endeavours were. And if the answer is nothing, and there's an issue around the making of non-derogatory statements, that could lead you into some difficulty. It's unlikely, but it's possible. And other common clauses, benefits in kind. So any other benefits that you're offering to the employee. Again, it's the beauty of a settlement agreement. You can come to all sorts of agreements. Not unusual to find that post-employment health policy is continued, perhaps because the life of the policy continues post-employment anyway. Sometimes employees ask to be able to use company cars. I've seen that quite a lot, where perhaps there's a lease which doesn't expire for a few months, and the employee says, well, would you let me take the benefit of the car in that period while I get a new car, etc. Nothing wrong with them, they just need to be well drafted and clearly drafted, particularly where company property is being held on to. I have to say, I often say to my clients who are making arrangements for people to retain a company car, are you sure? And do we trust this particular individual? Because post-employment, if things haven't gone too well and the employee perhaps doesn't feel much loyalty, you may have difficulty getting the car back or getting it back in a good condition. I've had circumstances whereby we've had to send recovery round to recover a vehicle because an employee simply decided they're not going to help in terms of returning the car. So it can create difficulties, cars returned in poor condition, etc. Whilst you may have remedies against that, it's hard to police and it gives you an extra headache. So absolutely possible to draft in benefits in kind, just be a little bit wary of who you offer them to and for what period of time. Okay, so some common problems that come up, they come up usually at the negotiation stage when there are issues. This next case, Newbury & Son Microsystems, a little bit legalistic. It's usually something that lawyers would be concerned with and bothered about. But if you do conduct negotiation directly with other solicitors on behalf of your company when you're negotiating a settlement agreement, then you should be aware of this. You need to mark all of your negotiations with not only without prejudice, but also subject to contract. So what happened in this particular case, this Newbury case, was that the parties reached an agreement via without prejudice correspondence, but not marked subject to contract, about what was going to be in the settlement agreement. Somebody made an offer, the other person said, yes, that's fine, we'll go with that. At some point, that offer's then been reneged upon, and the individual has said, come back and claimed, or one of the parties has come back and said, right, okay, actually we did reach an agreement and we've got that agreement evidenced in none without prejudice correspondence. And the other side said, Sun Microsystems said, well, actually, it wasn't in the contract. We hadn't put it into the settlement agreement yet. We hadn't signed it off, and therefore it's not an agreement. But they hadn't written subject to contract in the email. So it's all quite complicated, this, and I don't really want to get into a big technical description of it, but just be aware if you are conducting written negotiation with the other side on behalf of your company when dealing with a settlement agreement, have the words without prejudice and subject to contract somewhere in the heading or in the letter. It just offers you that little bit of extra compensation, extra protection, because what that means is that it's not actually going to be binding until we've put it in the contract and agreed it in a contract. It's not going to, this correspondence isn't going to bind us, so just be aware of that. Whole agreement clauses. All settlement agreements can usually contain a whole agreement clause, which says that whatever's gone on before, whatever other contracts are in place, they all fall away in favour of this settlement agreement, and this governs what happens now in respect to the person's termination. Usually fine, no problem with that. However, there may be bits and bobs in the contract of employment, for example, that you do want to be included in the settlement agreement and that you do want to continue post-termination. Most obvious one is post-termination covenants. If you have a whole agreement clause in your contract, your settlement agreement, then anything in the employee's contract of employment that isn't reflected in the settlement agreement is going to fall away. So we have had, I am aware of circumstances, not my cases, don't hesitate to tell you, whereby people have signed settlement agreements which have whole agreement clauses in them, and then the employer has tried to enforce the terms of the contract for post-termination restrictions. No chance at all. They've signed something which says whole agreement. So another one is confidentiality. So some people have very detailed post-termination confidentiality or confidential information clauses in the contract of employment. You've got two options. You either cut and paste them into your settlement agreement, or you simply refer to them in your settlement agreement and say, notwithstanding clauses, 10 and 9 in the settlement, in the contract of employment, which we intend to carry on post-termination. So very, very easily dealt with, but often overlooked. And the final one there is jurisdiction. Would only really bother you if you are an international business and you have individuals who work abroad as well as in the UK. Obviously, UK settlement agreements are going to have jurisdiction for England, the courts of England and Wales, or the courts of the UK. If you've got an individual who works in other jurisdictions, you need to make sure that they're not free to pursue employment tribunal claims in other jurisdictions. About 2 years ago, there was quite a well-known case of an individual who signed a settlement agreement in the UK and then pursued a claim for bonus, a very expensive bonus claim, which the employer thought had been compromised in a different jurisdiction where he worked. I can't quite remember it was abroad. And the employer's attempt to say they couldn't bring that claim failed because it wasn't covered in jurisdiction. He was entitled to bring a claim on the facts in that jurisdiction, and therefore that is what he did. So again, just be aware of that if you've got people who work abroad, or there's a chance that they might be able to claim that they are able to pursue a claim in a foreign court. Challenges to validity. Not very often a settlement agreement is challenged for validity reasons. What you'll usually find, there's an allegation for a failure to comply with minimum requirements. So all the stuff I was talking about before, that has to be in a settlement agreement. If it's not there, an individual or either party can challenge its validity and therefore its enforceability. So it's really important that we get those basics right. The last three I've mentioned there because they are possible: duress, misrepresentation and mental capacity. Very rare. I've never come across them in practice. If you were to have a situation where you feel an individual is entering into a settlement agreement but doesn't have the mental capacity to do so, you should probably flag that with the individual at the time and see if there's anything you can do to negate that. Could be an issue. Very unlikely that anybody successfully claims duress or misrepresentation, really for the main reason being that the individual has to go to an independent solicitor to get advice and to get these signed off. So it's going to be difficult for them to claim duress if they've gone along to a lawyer and been given proper advice and they've described the circumstances of their dismissal as they're obliged to do. That's their opportunity to raise issues there. So very, very rare, the last three. The main one is the first one, failure to comply with minimum requirements. Okay, enforcing a settlement agreement. Most commonly I'm asked, if I just switch very quickly to the next slide, these are the most common questions I'm asked. What is the effect of a failure by the employer to pay the sums due under the settlement agreement? And what is the effect of breach by the employee of the confidentiality clause? Now, the answer to the question, how do you enforce a settlement agreement if either one party or both parties don't comply, if I just jump back to the slide before, the answer is it depends on what the breach is and how your settlement agreement has been worded. So looking at that second bullet point there, breach of a condition entitles the wronged party to terminate the contract entirely and claim damages. Breach of a warranty entitles the wrong party to claim damages only. So if something's expressed as a warranty and it's been breached, all you will be able to claim is any loss you've incurred as a result of that breach of warranty. You won't be able to declare the whole settlement agreement void and you're not paying any monies under it, etc., etc. So it depends on the breach and depends on how the settlement is drafted. Going back to the next slide then, what is the effect of the failure by the employer to pay sums due under the settlement agreement? Generally speaking, settlement agreements aren't drafted to make payment of the settlement monies a condition of the whole agreement or a condition of the employee waiving their claims. So the settlement agreement would continue to be binding in every other way on both parties, and what the employee would have to do then is to seek redress for breach of contract through the county court. Now, obviously, that they're drafted in that way really to protect the employer, a little bit more favourable to them, because what we don't want is to miss a sort of payment, be late by 2 days, and have the employee say, right, whole agreement's null and void, I'm off to court, I'm going to bring my claim. It wouldn't work like that. They would have redress only the way that most settlement agreements are drafted, for payment of those monies, so that it does offer a degree of protection. Obviously, my advice to all employers is pay promptly. The whole point of a settlement agreement is to get things done, dusted, and out off your desk and out of the way. And there's nothing sort of more painful than having a settlement agreement limping on for weeks and weeks after it's supposed to have been settled because certain things haven't been done or not been done on time. Again, what is the breach by the employee of the confidentiality clause of a settlement agreement? It depends on how it's drafted. Is it drafted so payment is conditional on compliance with confidentiality? Generally speaking, they usually are, but sometimes they're not. Sometimes we wouldn't want payment, we wouldn't want the agreement to fall away because of breach of a confidentiality clause. What we might want to do is draft it so that it's a warranty only, and if we actually suffer a problem as a result of a breach of confidentiality, then we can go ahead and bring a claim for those damages. Again, usually in both parties' interests to have the agreement stay, so stay intact, not void. But it's up to you. It depends on the circumstances, and it depends how strongly you feel about certain points. So again, that's something you can bring up or consider when you're drafting a settlement agreement for an individual. How important is confidentiality going to be in this case? A very sensitive case, it might be very important. A very sort of bog standard case, not particularly difficult case, it's going to be not very important at all, really. So it's up to you. Failure to pay legal fees, that last one there. The good news is that the solicitor who advises the employee doesn't have a contract with the employer. They have a contract with their client. So what would usually happen if you fail to pay legal fees is the solicitor will chase the client and the client will chase you. So the employee will chase you. Again, if you've agreed to pay them, my advice is get them paid, get them out of the way. But it does happen. It can often happen simply by being overlooked, if I'm honest. Okay, practical tips. We've covered other remedies available, but I thought it might be useful to just put them out here. References. Tribunal can't order a reference, so this will often be very valuable to an employee who's leaving your employment. You can introduce fresh post-termination restrictions, or you can agree to waive them for employees. Again, this can be a very valuable settlement to either party, really, and it's something a court can't grant. You can offer outplacement resources or coaching. Seeing coaching come into it more and more, actually. So coaching on maybe career change or being made redundant, or looking at how to go forward in life post redundancy, etc. I am a qualified coach, so if anybody wants to explore that, let me know. But I'm finding that it's taken off a bit more and finding its way into more and more settlement agreements. Training. I've seen people ask for training. I've seen people ask for training of managers after they've left. So one particular case that springs to mind, a lady was claiming she was bullied, and part of her settlement agreement contained the proviso that the employer would, within 3 months, I think, whatever it was, of her leaving, they would carry out equality and diversity training and some bullying and harassment training as well. So an unusual remedy, but one that was valuable to the employee, and they were able to provide. And the other one is to retain equipment. Again, laptops, telephones and telephone numbers. Valuable and useful to the employee, may not cost the employer very much, or if anything at all, to be able to offer them. So always, be prepared to think laterally in terms of how we can get matters settled. Don't act as if the employee is left before they've signed a settlement agreement. This is a really, really important one. And I actually had something like this relatively recently, whereby the employer was pretty much a case study in how not to carry out a protected conversation. Very briefly, the employee was called to a meeting. Somebody had raised a grievance about her. The business hadn't conducted any investigation at this point, but what they offered her a settlement agreement, so they had an off-the-record conversation with a protected conversation. So far, so good. But in that conversation, they said to her, "You need to sign the settlement agreement. You're going to be dismissed on Friday, and if you don't sign it, then you're going to be sacked." So they'd already set out in plain terms, we're not going to give you a fair hearing, etc., all that sort of stuff that you might expect them to say. They just said, you're going to be sacked. So you sign this or you're going to be sacked anyway. This is before they'd done any investigation whatsoever. The employee was then sent home. She had her pass card taken off her, her keys removed, and they made an appointment to meet her the very next day to get all of her company equipment off her, laptops, files she had at home, etc., everything. So they were acting as though she'd already been sacked or left the business, even though she was still theoretically, well, she still was employed, no doubt about it. And she hadn't yet decided whether or not she wanted to sign an agreement or whether she would prefer the business to conduct an investigation and see where that went. I think that the employer had left themselves extremely vulnerable to either a claim for constructive unfair dismissal, whereby the employee resigns, claims improper conduct during the meeting, wherein she was pretty sort of put under some duress to leave and sign an agreement. And therefore that conversation would have been disclosable at tribunal. But also there was an argument that she'd been sacked because she came away slightly confused at that meeting. She naturally believed she had been dismissed already because of the way they treated her and the manner in which they'd acted. So if she had chosen, she did go on to settle, although we were able to negotiate better terms because of these defaults. But had she gone on, she would have had a reasonable case for unfair dismissal, I think. And actually, the employer didn't need to put itself in that position. It was the employer's conduct at the meeting itself that put it in that position. Had it simply gone forward and simply offered her the agreement and said, if you don't accept it, that's fine, we will come back and conduct a fair procedure and we'll see where we get to, even though we don't think it looks particularly good for you. But they acted in such, as soon as she'd left with that settlement agreement, they acted in such a way. And in fact, she also got a text message from a colleague saying, sorry to hear you've left, the following day. So, you know, they really boxed themselves into a corner. So don't act as if you've left, somebody has left before they've signed the settlement agreement. They haven't, they're still your employee. And again, we come back to that original premise, which was always conduct without prejudice, protected conversations in such a way that you won't mind if everybody knows what you've said. It's not going to create a difficulty for you, even if it comes out in court. Don't cut and paste settlement agreements. Employment law changes at a rate of knots. We get updates every single week, never mind every month or every year. And so we are always tweaking our drafts and our agreements to make sure they're compliant. But also, unless you're very, very legally savvy, if you are using a previous draft, then make sure, do send it to your legal advisor, just get it checked. It won't take very long. And you need to give them the information they need to tell you that you've done everything you should. For example, you might use a draft for employee A, perfectly fine, and the next day you use it for employee B, and you've missed out the fact that they've got post-termination restrictions and the whole agreement clause could do with amending, or there's something to do with the company property that needs changing. You know, one size doesn't always fit all. So if you've got a good draft, that's a great start, but unless you're really, really legal savvy, or you're an in-house lawyer, you know what you're doing, just always give them the attention they deserve. They may need updating, they may need checking. Make sure your legal advisor has all of the relevant information. Sounds really obvious, but I'm forever being sent drafts on email saying, could you have a quick look at that and tell me if it's all right? I don't have any background. So it's left to me to make, the sort of make guesses really. Do they, what does their contract say? Do you need to consider anything with regard to post-termination restrictions? Are there any particular confidentiality issues? So it makes it quicker if your lawyer has all the information available to them. Otherwise, they're just going to check what's there and say, well, it all looks fine to me. If you haven't given me any background, that tells me things need changing. So, don't be afraid to throw some information at your legal advisor just to make sure everything's okay, particularly in a big settlement. Or an important settlement, and double check your figures. Happens time and time again. In fact, my standard response now when I check things is, are you happy with the figures? The figures you have given me are these. Are you happy with them? Because if they've got them wrong to the employee's detriment, the employee is usually the first one who spots them. So they'll say, no, that's not right, I need more than that. They probably wouldn't be so forthcoming if they're getting more than they deserve or more than they expected. And it has happened more times than I'd care to mention when during the course of a negotiation one of my clients has gone, oh, the wrong figure in there, that was from the last settlement agreement, I left it in by mistake. Impossible. Well, it's pretty much impossible to rectify a mistake in relation to figures if you yourself has proposed the figure and that's been agreed. So always double check your figures. Something basic, but just bear it in mind. Okay, so if you have any questions, I'm just looking at the questions here and I haven't had any through during the presentation. If you want to quickly type a question to me now, please feel free. Otherwise, my details are at the end of the slides. Let me just pull it up for you. My telephone number and my email address. If you've got any questions or queries, if you've got a settlement agreement you want me to look at, or you've got any particular concerns, then feel free to give me a call or drop me a line. I'll be really, really happy to help. And nothing's come through, so and we're right on the hour. I thought I'd be less than an hour, but I've obviously talked more than I expected. Thank you very much for listening, and hopefully I'll speak to you soon. Thank you.